Oops. So how are we today? Excuse my little dog in the background, or big dog. She will be joining us here and there. The perks of working from home. My name is Lenny Cheng, or Leonor Cheng. I am a workplace law and corporate lawyer. I also did my Bachelor of Law at Deakin, and I'm very glad to also be presenting to, soon to be graduates on the new positive duty to reduce sexual harassment, as you can see here. Just a brief disclaimer before I continue. There will be sexual harassment and related conduct discussed openly in my presentation today. So if you find this distressing, feel free to step out of Zoom at any time. And I will be uploading a version of this slide, so you can tune in at a later stage if needed. It will be transcribed so that it will be easier to digest. I will also be using a short cartoon clip as a teaching tool. Now, this is not to trivialize or minimize the matter. It is just to keep the material engaging while allowing us to recognize the patterns of inappropriate conduct without relying on graphic or real-world material. So let's begin. I want to begin with a case study using SpongeBob, and I love SpongeBob. I hope everyone's seen SpongeBob. The Krusty Krab is a great example of a workplace that has conducted various workplace breaches. So I love using the Krusty Krab as an example. He regularly underpays his staff. There's food regulatory problems. He overworks them, and I'm not really sure if SpongeBob is actually paid sometimes. But in this episode, it's called That's No Lady. And in this episode, Patrick is the one who gets hired by Mr. Krabs. So what happened is Patrick disguises himself as a woman, and he calls himself Patricia. Now, he or she was then hired to work at the Krusty Krabs. Now, we should respect Patricia's pronouns at this stage. She wants to be a woman, so we're going to refer to her as a woman until Patrick transitions back. But anyway, the Krusty Krab is owned by Mr. Krab, as shown in the photo on the screen. And Mr. Krab here doesn't treat his employees very well. So this video is compressed to 2.5 minutes, and there's a lot going on, and it's very quick. I want you to identify any potential sexual harassment in the clip and any legal action that Patricia can take. And I want you to fill out box number 1 of your worksheet given to you. So what's going to happen is, because of copyright reasons, I can't record the video and have it online. So what I'm going to do is pause the recording. Anyone tuning in outside of the Zoom can actually find this video on YouTube. If you just type in That's No Lady SpongeBob, it will show up. And it will be, it will be on YouTube, I suppose. I think the Nickelodeon channel has uploaded it. I think, don't quote me, but it is there. So what I'm going to do is I'm going to pause the recording, and we will all watch the video together on Zoom. Anyone tuning at home can tune in their own time. I will then break everyone out in their breakout rooms, and then you will then fill out box number 1. We will then come together, and I will continue the presentation, and the recording will continue. Are we good with that? Great. So this is it. Wait, we don't want that. Oops, sorry. My bad. Don't sue me or sue me. I don't care. I do care, but it would cost me nothing if you sue me, really, because I will be representing myself. But yes, Nickelodeon, don't sue me for that 2-second clip. That was a mistake. How do I do this? Give me one moment. Okay, pause. Okay, how did we find that? Did we identify any sexual harassment? And can Patricia take any legal action? Hopefully you got plenty of information in box number 1. I'm mindful of time. This is actually not the most important part of our presentation, unfortunately. So I've listed some breaches that I found that was the most apparent. And I'm just going to smash through it. We can discuss this at the end if we have time. But yeah, I'm just mindful not to go over. So this is what I found. Yes, there was. And you will have found many more, but yes. Firstly, there was instant hiring and touching by Mr. Crab when he hired Patricia. He pretty much hired her based on her physical appearance and the fact that she was a woman, put his arms around her, and had no acknowledgement of her prior credentials or any other aspects, criminal records or anything. So this was, well, there is, I would say, sex-based discrimination, but in the opposite direction, sex-based privilege. But yes, it was harassment. The next thing was the most alarming part of the video. Mr. Crab stages a date at work. Now, this is the clearest example of power imbalance. And pretty much what Mr. Crab did was Mr. Crab gave Patricia a work task, which is, hey, Patricia, bring this order to that table. And when she arrived to the table, it's Mr. Crab sitting there and then saying, I can't finish all this food. Come and sit down with me. And then proceeds to profess his love for her. That is very inappropriate. I don't think you need me to specify that. But yes, that is a sexualized environment. And that was implied pressure put on Patricia. The poor girl. Now, Squidward then wraps his arms around Patricia. That was unwanted physical contact. I would say also, as the episode went on, there was a bit of stalking by Squidward. I don't know if you guys saw that. It's not funny, but it is, it's cartoonish. Anyway, continuing on. Patricia also said no many times. There was almost ongoing harassment by all the staff. And she was proposed to many times for dates and if she's free. It pretty much led to a hostile work environment. There was no one for her to turn to. Even management was part of it. Management didn't stop it. Now, lastly, Patrick was then fired for being a man because he was sick of the treatment being Patricia. He came out as being a man. And then Mr. Crab says, oh, you're a man. Oh, well, you're fired. So that is gender-based discrimination. And yes, that's not allowed. So can Patricia take legal action? Yes, she can. She could take so much. That workplace was horrendous. There was so much crap going on. She can really, nail it in if she wanted to. The first thing that we would recommend an employee do is to take internal workplace process because it's the quickest path. But in this case, and in many cases, the employee doesn't have an internal workplace process to report this to. Sometimes you may find in our cases, HR is even in on it. Sometimes like, oh, it's just a joke. So if there's none, where else can she go? Next is the criminal path where she could go to the police. Now, this can be daunting for a lot of people because in all these paths, their names would be kind of made public going forward. internal, it's within the corporation, but outside of it, your name will be made public. So yeah, that as well, having that attached to you. Also, compiling evidence, being questioned and having to reiterate what happened again and again and again with multiple officers at a time. It will be a very drawn out, many-year-long process. She can file complaints. So she can go through the Australian Human Rights Commission or the state anti-discrimination bodies. And then they can look into it. She can go through Fair Work, which is our favorite, after all, it's workplace law. So she could file F2 or F8. She could go through OH and S regulators or workers' compensation. Now, this is more difficult because it has to be an injury. Lastly, I would kind of advise outside of this, but civil claims is probably where there's no other options. There's a lot I want to say about the civil claims one, but we would try and take that as a last path. It is the most expensive, I would say, because they will be forking out their own lawyers. Yes, and union and advocacy channels. Now, this is more for advocacy. I don't think it would have any teeth or compensation as much as Patricia would like. She may change things in future and make the matter more noticed by the public. But anyway, moving on, our favorite has been Fair Work, obviously, been through that. But however, all of these pathways require that harm be done. So they're reactive. They only really tick off when something has been done to Patricia. Patricia would then have to endure the behavior, collect the evidence, and initiate the complaint. And it will be years and years and years of cross-examination and compiling evidence and text messages and pictures and emails and witness statements and whatnot. And many witnesses may not even come forward. So as we have seen also, reactive litigation is very limited. For example, we did have a case with Fair Work where we did have a client that had something happen to her in this nature, sexual harassment. But because it happened before March 2023, and she has suffered for so long, years and years, she left around 2023. We couldn't do anything about it because Fair Work's ability to compensate only kicked off in March 2023. Does that make sense? But even if it happened afterwards, yes, the damage is already done. You're really compensating retroactively. And there is also a limit to really how much you could claim. It's not an unlimited threshold based on whatever figure you want. So thankfully, we have a thing called positive duty. So what is it? So positive duty is when employers must take steps to prevent or eliminate sexual harassment. And this is led by the Australian Human Rights Commission, who can now enforce compliance for this duty. So I just want to go through a quick timeline because this new positive duty took a long time to come about. It wasn't just overnight, let's just enforce this new law. It came from years of inquiry and law reform, which started back in 2020 when the Respect at Work report was released. Now, what is the Respect at Work report? Well, it was a national inquiry led by Kate Jenkins, the Sex Discrimination Commissioner at the time. She oversaw a national process that included surveys, public submissions, and consultations with workers, employers, unions, lawyers, and survivors. Now, the reforms are based on real evidence and real lived experience. So this became the blueprint for law reform, including the introduction for positive duty. You can actually access this yourself. The report is on the Human Rights Commission website. I won't go through the whole thing. It is 932 pages, but I will give you the key findings of what the inquiry found. Oops. The report itself is very comprehensive. I scrolled through the contents for you here to show you that it is an actual PDF that you can look at. Okay. So the inquiry has found that, firstly, sexual harassment was really common. 1 in 3 Australian workers has experienced sexual harassment in the last 5 years, and women more than men. Most of the perpetrators were men. Next, there was significant underreporting. So only 17% of the people who have experienced sexual harassment in the last 5 years have made a formal complaint or report. And also, harassment was often repeated and ongoing. So half the incidents were repeated and many continued for more than a year. This was a systematic issue and not isolated. So together, the inquiry concluded that the law was way too reactive. It only happened after the harm has occurred. And pretty much complaints relied on traumatized victims, and the complaints process re-traumatized victims. And employers also had no obligation to prevent harm at all. It's just whatever happened, we'll face a lawsuit as it comes. So overall, it was very disheartening and many victims were dismissed. The inquiry then made 55 recommendations. The most important for us is the new introduction to positive duty on employers to reduce sexual harassment. So after 2020, in November 2022, Parliament then passed the Respect at Work amendments. Then in December 2022, it formally became law. And then in December 2023, the Australian Human Rights Commission, AHRC, enforced powers. So that means that they can now begin monitoring and enforcing compliance. And that's where the enforcement powers began. Now, there was a bit of a jump from December 2022 to December 2023. There was a year. The reason why it wasn't an accident, the reason why the AHRC didn't kick off compliance yet was because they were allowing a year for current employers to get used to the new law. It was called a transitional period. And yeah, they could make any changes to their operations if needed. So how does the AHRC enforce positive duty? Let's go through the process. First, they need a reasonable suspicion of non-compliance. Now, this can come from an actual complaint and report, but it doesn't always have to. They just need a tip-off, okay? Then the AHRC opened an inquiry into compliance. Now, this step is when pretty much the employer is then notified and they are forced to engage. They can't, weasel out of this. Next, the information gathering process begins, where the AHRC sees whether or not the operation of the business is compliant. So they may require documents, information, examine witnesses, assess systems, policies, and practices. So they will assess the company overall. Then, if they find that the corporation is non-compliant, then they will take regulatory responses. Now, there's a few responses that they can take depending on how severe and how cooperative the businesses. So the first pathway they could take if their business is very corporative is they can invite for voluntary support. So they simply make informal recommendations, pretty much. The next option, if the I would say non-compliance is more severe and the business is resistant to changes, they may enter into a legally binding agreement to fix the issues. And the last option, and the firmest one, is they may seek a formal notice requiring specific actions to be done in a time frame. Now, the last option would require court enforcement. So that AHRC can take the business in question if they're very resistant to any of the recommendations. They can take them to court, and they can take them to the federal or the federal circuit and family court for a court order. There's been no major cases that have gone this far, which I suspect that many of the cases have been resolved and non-compliance have been resolved probably early on. I don't even think it requires as far as option C at this stage, because it's great. That means in this case, the less cases we see, the more it's working. Okay, what is the positive duty? Now, I've gone through this in principle, but I want to go through what the law actually says about positive duty. So if you look it up yourself on the Sex Discrimination Act 1984, Section 47C, it says, and I quote, an employer or a person conducting a business or undertaking must take reasonable and proportionate measures to eliminate, as far as possible, relevant unlawful conduct. What relevant unlawful conduct means? Well, it's not just sexual harassment. It also includes sex-based harassment, sex discrimination, conduct that led to a hostile environment on the grounds of sex, even victimization, just to go through it very quickly and plainly. Now, I would like to also note that in the UK, they have also amended their Equality Act in late 2024. So we had our amendments in 2022. So I would say between you and I that the UK copied us in enforcing positive duty. So we've, just saying, we're leading the world stage here. But theirs only includes sexual harassment, while ours include a broader scope, which is great. I'd like to see that globally there's going to be a greater shift, because we do have a positive duty also, I believe, in a different way in Canada as well. So this is not just an Australian thing. This is a global shift. Okay, so other considerations. So Section 47C also considers other things like the size, nature, and circumstances of the business, the resources of the business, the practicality and the costs, and any other relevant matters. What this means is they don't expect businesses to be able to enforce compliance in the same way. Sometimes it's simply not practical. So they kept this very, I would say, flexible on purpose. But that's also bad for us, because firstly, we have a new law without much precedence, and that is quite flexible. So how do we navigate this as lawyers and future justice workers? Now, the law doesn't tell you how to run your business. So these are some things that I would think that are reasonable and proportionate. Your opinions may differ, by the way, but This is what I personally think is fair. Firstly, I think there should be a strong workplace culture and leadership, and there should be a zero tolerance policy, pretty much. This will eliminate all gray areas and possible slippery slope that would lead to an investigation by the AHRC, which no one wants. Sorry to take the fun out of everything, zero tolerance. Anyway, next, there needs to be a clear policies and procedures. Now, I think it needs to be out in the open, personally. And you know how they have manuals on how to lift things or heavy objects, and they stick it on kitchens and stick it on printers, and how to handle this, how to handle that safely. It should be done with sexual harassment and sex discrimination as well. It should be stuck in the staff rooms, staff kitchen, bathrooms. And this would allow the topic to be discussed in the open without it being a hidden matter or a shameful matter. Next, there should be training and education. As with a lot of the modules we've done, if anyone's worked in the workplace for long enough, you would have modules on food handling, or you would have modules on how to arrange your cords so that it's not an OH&S issue or a fire hazard. There should be something to do with sexual harassment and sex-based discrimination. It should be treated as serious as physical safety. And I'd like to work together with a company on this, actually. So do reach out if you want to put together a module that is compliant. Next, having proper reporting pathways. And yes, you should have that designated staff that is trained for this specifically. Now, I don't think we should push everyone to HR. I do think that HR can be good in some circumstances, but HR is not always perfect. And if HR is always perfect, we would not see half the cases we see in Fair Work. So it hasn't been perfect. So someone needs to be trained and be the reporting person that other staff can go to. So what reasonable and proportionate also depends on context. A small business would run very different to a large business, and we don't expect a large business to cut corners and run like a small business, and for small business to have the resources as a large business. So what is reasonable and proportionate based on the business size? This is what I think again. Your opinion may differ. So what I think is a small business may have basic training. They may have like a policy, someone to report to, pretty much. A medium business may be able to afford extra compliance measures. They may be even able to seek legal advice to work with the operations. Now, a large business, I would expect, would have a dedicated compliance team. So let's go back in time before Mr. Krabs hired Patricia. And knowing what you know now, with the gift of foresight, what would you do to advise Krusty Krabs to avoid the sexual harassment matters that happened in the episode? I'm going to pause the recording again and break everyone out in the breakout rooms. If you can all fill out box number 2 of your worksheet. And yeah, we will come back together from there. So what does this new positive duty mean for lawyers and justice workers? Well, I think there'll be a lower overall litigation costs due to earlier regulatory intervention. There'll be reduced strain on the courts, and we love that. Judges love this. Fewer matters escalating. The earlier we can resolve stuff, the better. Pretty much, we don't want not that we don't want victims speaking up. We don't want cases dragging on for years and decades even. And we don't want the financial strain on the victims. It'll be a shift in legal work from reactive litigation to proactive compliance and prevention. Now, I need to note that I don't think it will eliminate litigation. I do think that you'll be perhaps possibly in the future hired to prevent issues, which is great. There may be a growth in advisory work, and there may be an emergence of a new practice area focused on sexual harassment and psychosexual social risks. So, questions for you. Now, this new duty has created more questions than answers. So there isn't much questions I would say that I can answer for you. It's up to you at this stage, because how would you define reasonable and proportionate? Where would you draw the line between practical compliance and over-engineering risk controls? How would you advise a small business differently from a large corporation? If employees are okay with it, does that meet compliance? The reason why I added this in is because we're entering into a philosophical aspect here, I suppose. Let's face it, this is a very metropolitan, way of seeing things. We are. I would say I am a snowflake. I am a city girl through and through. But then some businesses that I have encountered who are more rural have a different culture, and their staff can joke about certain things that is not okay in our city world. So to what extent are we imposing our worldview onto everyone else? If they're okay with it, can we just, let it go? Or do we have to meddle in everything, kind of thing? I'll leave that up to you. That's a question for you, not for me. I will have my own opinion on that. But yes, and how about multinational companies with cultural differences that, move to Australia, have a department in Australia? How would that work? Or have bought out an Australian company where the parent company is abroad and do things very differently? And how would this shift workplace culture? So I find this interesting because the onus is now shifted from the employee to prove that something was done to them to the employer to say, no, I need to proactively prevent something from happening to the employee. How would this also impact other areas of life and workplace law? How about ethics? How about other aspects where the employees are the one having to come forth with all these matters, but then in future maybe we'll be looking at the employer like saying, hang on, you should have seen this coming. So that concludes my presentation for today. I hope that was really insightful. I will end the recording so that everyone can, share their ideas and findings. I do hope you guys enjoy the rest of everyone else's presentation on different modules. It'll be quite interesting to see how workplace law is shifting in real time. Okay, so also everyone can submit their workplace worksheet to me. That'll be great. And I will take a look at that. For the meantime, I hope you enjoy everyone else's modules on workplace law and the new updates and changes.